alone cometh all counsel, wisdom, and understanding. We, thine unworthy servants, here gathered together in thy name, do most humbly beseech thee to send down thy heavenly wisdom from above, to direct and guide us in all our consultations. And grant that we, having thy fair always before our eyes, and laying aside all private interests, prejudices, and partial affections, the result of all our counsels may be to the glory of thy blessed name, the maintenance of true religion and justice, the safety, honor, and happiness of the Queen, the public weal, peace and tranquility of the island, and the uniting and knitting together of the hearts of all persons and estates within the same, in true Christian love and charity, one towards another, through Jesus Christ our Lord. Amen.
Yes, just before that, just before Senator Bunting, I just wish to bring to the attention of the Honourable Senate after I call the Senate for Friday, April 30th, to order, bring to the attention of the Senate the passing of former Senator Ambassador Anthony Johnson, and indicate that I will take tributes in relation to the passing of Mr. Johnson at the next meeting of the Senate, which I anticipate to be next week, Friday. And I also note the absence of the Leader of Government Business, Senator the Honourable Kamina Johnson, for reasons that may be obvious. Senator Hill, you have conduct of the matters of the government for today, and you have my permission to sit in a seat other than your own. I don't know if Senator Samuda wants to come down, and Senator Campbell, whether you want to come down or you want to stay where you are. I believe you are presenting bills today. Is that correct? Okay. Thank you. Mr. Bunting.
Thank you, Mr. President. As discussed with you and with your permission, Senator Lambert Brown wishes to make a personal statement under Standing Order 18.
Members would have heard. There's no problem. All in favor? Thank you, Brown. Senator Brown, please.
Last Friday, during the debate on the motion for adjournment, I expressed my personal view in relation to anyone violating any female member of my family. Those are my personal views. I urge no one else to act on those views. Neither do I urge such personal views as public policy. They remain my personal views. However, on reflection, I accept that the Senate was not the place to expound such a view. My comment was made in the wrong forum. I therefore withdraw it from this forum.
Thank you, Senator Brown. Statements by ministers. Announcements.
Laid on the table of the Senate today are the following. Ministry Paper number 27 of 2021 entitled Social Pension Program. The notification of the inflation target under the Bank of Jamaica Amendment Act 2020. Annual report on audited financial statements of the Independent Park Limited for the years 2016-2017 and 2017-2018. Annual report on audited financial statements of the Port Authority of Jamaica for the year 2017-2018. Annual report on audited financial statements of the Jamaica Mortgage Bank for the year 2019-2020. Annual report on audited financial statements of the Jamaica International Free Zone Development Company Limited for the years 2016-2017 and 2017-2018. The Judiciary Salaries Order 2021 under the Judiciary Act, and the Independent Commission for the Judiciary Inquiry and recommendations on the adequacy of salaries and benefits for judges 2018-2020.
Thank you very much, Madam Clerk. Bills brought from the Honourable House of Representatives. Petitions. Papers. Reports from committees. Okay, sorry. Notices of motions given orally. Questions and answers to questions. Motions that may be made at the commencement of public business requiring notice. Motions relating to the sitting of the Senate. Motions for leave to introduce bills. The presentation of bills without the leave of the Senate first obtained. Public business. Minister.
Thank you, Mr. President, and thank you for allowing me to speak from a seat other than my own. There are 3 items for public business today, and they will proceed. I'm not sure I need that, but we'll go ahead. They'll proceed in the following order. The Protected Disclosure Act will be tabled and piloted by Senator Leslie Campbell. The second will be an act to amend the Justices of the Peace Act and 4 connected matters, which will be piloted by Senator Matthew Samuda, and Senator Samuda, will also pilot the Airports Economic Regulations Act, to be completed today. Those are the 3 items, Mr. President. Thank you.
Thank you very much. You're going to take Mr. Campbell first, Minister Campbell first? Yes. Does the minister want to move a bit closer down, or are you comfortable there?
Thank you, Mr. President. I believe I'm sufficiently comfortable in this area. Mr. President, for my part, I sincerely hope the day will come when we take these matters as a matter of formality, and we simply vote that given that this matter was tabled as far back as the 12th of February of this year. Be that as it may, Mr. President, what the resolution seeks to do is to bring into line what ought to have been done some time ago. That is on to to bring and to protect the persons who would normally disclose information in a workplace. That is, when the disclosure is done to an fellow employee or to the employer, that he would not suffer any serious repercussions. That, and in order to remove the tax administration from under the functions under the Act, and to give it the new name, which is the Tax Administration of Jamaica. Mister, I sincerely hope I don't suffer the same my command of the technology, Mr. President, has been found wanting in the past, and I sincerely hope I don't suffer the same. Oh. And you see, the lead, or lack thereof. Yeah, it's more like it. Mr. President, the Protected Disclosure Act empowers employees to disclose improper conduct by their employer or fellow employees without fear of occupational repercussions. Section 9 of the Protected Disclosures Act states that the disclosure can be made to the prescribed person listed in the first schedule. Among those entities listed are the Contractor General, the Commission for the Prevention of Corruption, and the Parliamentary Integrity Commission. Additionally, Section 21 of the Protected Disclosures Act contemplates the appointment of a designated authority to monitor compliance with that act. The body designated is the Commission for the Prevention of Corruption. And you recall, Mr. President, that the Integrity Commission Act was enacted to replace that commission along with the Contractor General and the Parliamentary Integrity Commission, so that the responsibility to prevent and sanction corrupt activities would be concentrated in one body. The law therefore requires amendment to remove the references to those commissions from the first schedule and to designate the Integrity Commission as the designated authority under Section 21. An unrelated amendment is also being made to delete the reference to the Inland Revenue Department and replace it with the Tax Administration, Jamaica. Mr. President, we want to place on record the government's commitment to stamp out corruption. And it's in to that end that these amendments are being sought. In furtherance of that position, Mr. President, significant sums have been allocated to the Integrity Commission, and the estimates of expenditure running through 2018 to 24 that will move from approximately 464 million to 872 million. Additionally, Mr. President, the budget for anti-corruption services from 2018 through 24 would move from approximately 211 million to 311 million. There is continuous dialogue with the anti-corruption body on ways to improve transparency and compliance. Accordingly, Mr. President, we are taking steps to not only talk the talk, but also walk it. Against that background, Mr. President, I invite comments from other members of this Honourable Senate in order to affirm the resolution which was tabled in this Honourable Senate on February 12, 2021. May it please you, Mr. President.
Thank you, Senator Campbell. Senator Brown.
Thank you, sir. We're being asked to approve the regulation, essentially changing the schedule in an act which was passed in 2011. That's before I became a senator in this parliament. But I recall attending the Joint Select Committee on behalf of the trade unions to comment on this act. I'm very familiar with the act. It is supposed to be called popularly the Whistleblower Act. When I made the submissions on behalf of the trade unions in 2011, I made the point that this legislation had too many hoops through which the reporting worker would have to jump to be protected. I'm therefore not surprised that despite the decade-old state of this legislation, that very few, if any, protected reporting has been made under it. And so I'd love to ask the minister in charge of this, could you tell us, Minister, whether even one single report has been made under this legislation? And I raise this against the background that we copied much of this from the United Kingdom. And many workers, Senator Gale, who have sought to utilize the provision of this legislation have ended up before the Employment Appeal Tribunal and Employment Tribunal in the UK trying to protect their jobs. Because despite utilizing this legislation, they still lost their job. So again, for me, this is a legislation we're amending today for form, because we have changed some other laws. But it doesn't make this legislation, the Protective Disclosure Act, the Whistleblower Act, meaningful in any way. Why do we keep a legislation on the book for 10 years that has not been effective, that has not been helpful in exposing the corruption, whether at Petrojam, CMU, Archos, or any government agency? Thank you for the Auditor General who have disclosed a raft of corruption in the public sector. But this legislation hasn't helped. Maybe it's time, Minister, for us to review and remove the hurdles to be crossed by the employee to be protected under this legislation. We on this side have no objection, though dead the legislation is, to amend the first schedule. But all we're doing is just putting flowers on the corpse. Time for some resurrection. Time to look back 10 years after and see how effective, if at all, this legislation is. So we may encourage more whistleblowing, so we can ferret out the corruption, so you can really walk the walk and stop the talk. You know, I say it simple. I would like, for example, to disclose as an employee, if I was an employee, that I am aware of government officials embracing a convicted rapist. But I couldn't use this. That person will have to come and whisper to Lambert Brown, and he takes it to the Senate. He may raise it. He may be censored. But such is life. Such would be life. All I say, time to review the Whistleblower Act. Time to review the Protective Disclosure Act. Let's put the flowers today on the corpse that it is by making the amendment. But let's just see if we can resurrect it so the citizens of the country can speak truth to power, speak out against corruption, get the corrupt convicted and removed from our system. But this legislation doesn't do that. I said it in 2011, I say it again today. I will vote for the flowers and the corpse. But I pray for the resurrection for the Easter Sunday. May it please you, sir.
Minister? Sorry, thank you, Senator Brown. Minister?
Mr. President, I thank my friend, Senator Brown, for his intervention. And whilst he speaks in rather mortified tones, if I may so I'd like to tell him that it is not indeed a corpse that we're presiding over. It might be ill and suffering some serious ailments. And may I just indicate to him that we'll take the appropriate steps to administer the medication which will bring some health, to restore some bodily functions to that which he complains of. And accordingly, Mr. President, I'll ask that the resolution be affirmed.
Thank you, Minister. Members would have heard the question put concerning resolution, the protected disclosure amendment of the first scheduled resolution 2021. Would have heard the question put by the Minister. Those in favor? Against? Ayes have it. Minister Samuda. Ms. Cohen, next.
Mr. President, I'm pleased to present to the Senate the bill entitled An Act to Amend the Justice of the Peace Act and for Connected Matters to allow a Justice of the Peace who resides or has his or her principal place of work in Kingston or St. Andrew to be appointed as a Justice for either parish. This is expected to result in more efficient allocation of the services of Justices of the Peace throughout both parishes. The Ministry of Justice sought and received Cabinet's approval to proceed with the amendment of the Act earlier this year. The bill was prepared, approved by the Legislation Committee, and subsequently Cabinet for tabling in the Houses of Parliament, and accordingly tabled in the Lower House on April 21st, 2021. Mr. President, you may recall that the appointment, jurisdiction, and conduct of the Justices of the Peace are currently established, regulated by the Justices of the Peace Act 2018. Section 8.1 of the Justices of the Peace Act states inter alia that the parish, as constituted by the Counties and Parishes Act, for which a justice is appointed, shall be the parish in which the justice resides or has his or her principal place of work. End quote. The Ministry of Justice administers the services to facilitate appointment of Justices of the Peace in keeping with the Act. Since the promulgation of the Justices of the Peace Act in 2018, there has been a significant increase in the number of Justices of the Peace across the island, resulting in a total of 9,000 Justices of the Peace island-wide as at March 31, 2021. This reflects a national JP to citizen ratio of 1 to 294. However, Mr. President, historically and currently, applications received for JPs to serve in the parish of Kingston have included persons who reside and work in the parish of St. Andrew, as there has been an interchangeable use of both parishes, leading to an infringement on Section 8.1 of the Act. Mr. President, Kingston is the smallest parish in Jamaica, occupying less than 22 square kilometers or 8.5 square miles. However, the nature of the judicial and economic activities in Kingston generates a strong need for Justice of the Peace services in the parish. Mr. President, although the Justice of the Peace citizen ratio for Kingston is indeed 1 to 62, an estimated 50% or above of all applicants and serving Justices of the Peace for Kingston reside and or have their principal place of work in St. Andrew, and therefore do not meet the legal requirements stipulated in Section 8.1 of the Act. This bill seeks to remedy the current language of Section 8.1 of the Justices of the Peace Act to ensure a fluidity and ease of access for persons to apply and become Justices of the Peace once they reside and have their principal place of work in either the parish of Kingston or St. Andrew. Importantly, Mr. President, the amendment will also validate the appointment of persons who have already been appointed to serve as Justices of the Peace in either Kingston or St. Andrew despite residing and working in the other parish. This amendment will allow the Custos of Kingston to appoint 55 persons awaiting appointment of Justices of the Peace for the parish of Kingston who currently reside and have their principal place of work in St. Andrew. In facilitating applications under either Kingston or St. Andrew, administrative processes and mechanisms would be implemented and enforced to ensure accountability of the process and deter any duplication of application to avert persons being rostered in both parishes simultaneously. Mr. President, I want to remind that the Justices of the Peace form an important and critical access point to the public in providing justice services. The Ministry of Justice continues to strengthen and provide current and up-to-date sensitization to all Justices of the Peace. Mr. President, I now commit the bill to amend the Justices of the Peace Act to the members of the Senate for their contributions and subsequent approval. Thank you, Mr. President.
Thank you, Minister Samuda. Senator Brown.
Yes, sir. So I have fallen the opening bats on this bill. Senator Samuda, we share the need for the efficiency and the effectiveness. We recognize that Justice of the Peace have played a very important role in our nation, chief of which has been the identification of citizens and the recommendation of citizens for jobs, passports, and other issues like those. And so it is important that we have sufficient JPs, because they're also used ostensibly to protect the citizens' rights against the state, and also as witnesses on behalf of the state against the citizens. So the role of the JP is critical, and we don't believe, having operated as a corporate parish, Kingston and St. Andrew, that we should be having legislation which pit one limited only to Kingston, one set limited only to St. Andrew, when the borders are almost invisible and doesn't even exist in real life. So we support treating the JP for Kingston as the JP for Kingston, St. Andrew, and vice versa. So, President, we also recognize that JPs can play some other roles since they are close to the citizenry. And right now, for example, I'm hearing the government speak of a third COVID wave. And we are of the view that JPs can be drafted as part of any public education that may take place in the prevention of a third COVID wave. A third COVID wave in which we have heard the chief medical officer saying we could have as much as 180 persons dying in the peak week. That's 5 into 7 into 180. It's giving us 20 odd per day. Numbers we haven't seen. And we just need to look at this television screen to see what's happening in India, to see why we should all work to avoid a third wave coming to Jamaica. And this opposition, once again, extend our hand of support, working with the government to prevent the third wave. We suggest, given the JP bill, that we should find a way to include the JPs in that public education. Another area in which the JPs could help, since they're so close, is this battle we have, Senator Hill, against violence against women. We could ask the JPs to play a role in talking to the males and also talking to the females. One thing the last week has taught me, for example, is that the JPs may play a role as counselor. For example, Senator Langmore, between 2011 and 2018, according to the Economic and Social Survey of Jamaica, put out by PIOJ, 5,286 cases of rape have been reported to the police. Of that, 2,610, let me repeat, 2,610 of those victims had no arrest in their case. No clear-up of those cases. 2,610 victims may need extra counseling, and maybe we could train the JPs to do some of that counseling. In other words, nobody found justice for them. Justice even being the arrest of somebody. That's how abused our women are. My personal views won't come into it. But that's how abused our women are. That's a stark data from the government. 5,296 reported cases. And we all know that the reported cases are less than the real incidents. 2,610 didn't even see Senator Samuda on arrest. And that data came from the Ministry of National Security. I make the point because the JPs may need to play a role in counseling those victims and ensuring for those victims the rule of law kicks in. Very important. Very important. And so, as I wrap up my opening, I'd like to ask Senator Samuda, since you pilot this bill, I know of the Lay Magistrate Association that brings together JPs across the country and in parishes. But what I'm not clear on, if there are standards which apply to the JP. For example, is it the Ministry of Justice or is it the Lay Magistrate Association who would act in case, unfortunately, a justice of the peace took a stool and beat a woman? Who would act in that case? Lay magistrate? Lay magistrate? JP? The police? Maybe there's no clarity on the incident. But I'm asking, if there are standards that would prevent or act if a justice of the peace took a stool and beat a woman, would he be allowed to remain a JP? If, would he be allowed? Secondly, what if a JP consistently, Senator Matthew, lied to the public? Would that JP, is there a standard which would negate the office of that JP? Just asking. And finally, if a JP is seen to be using profanity to members of the public, is there any standard that addresses that? I have no doubt that such a JP ought to be censored. But who would do the censoring? Who would do the censoring? I hope we'll find a way under the rule of law to make sure no man, JP or otherwise, beat a woman. I hope we could find a way to make sure no JP or anyone else using decent language where it ought not to be used in the public sphere. And I hope we would find a way to ensure honesty rather than lying be the preferred approach by JP or otherwise. Sad I can't say the same for senators, but at least we're debating JPs today. May it please you, Mr. President.
As a matter of, thank you, Senator Brown. As a matter of interest, can I see a show of hands as to which members of the Senate are justices of the peace? None? The registrar, the clerk, nobody, none of you are justices of the peace. Not even you, Senator Morris? No. But this is a very, very poor reflection on our membership. No, but the selection process requires an application, you know. Okay. It's of great interest to me to know that aside from the clerk, I am the only other justice of the peace in here. Yes, Senator Morris.
I am aware. I think, and Senator Natalie Campbell was probably a counselor. But at one point in time, I recall that counselors, Senator Sinclair, you have the title, but you don't get the stamp.
And I think members of parliament to exercise the function of a justice.
Okay, because that is where I was going, because yeah. I think, you know, it's something that we should look at.
Well, it's certainly something that I would recommend that the members make the relevant application. Senator Gale.
Thank you, President. Mr. President, let me start by accepting and agreeing to the objects or the objective of this legislation in bringing together administratively. You don't recognize me? In recognizing the efficiency that is going to be created by the strategic objectives and the scope of this legislation. I think, though, and I hear the concern being raised by the President in terms of those of us who are not justices of the peace. Let me use the opportunity to commend those, however, who have thought it to take on that awesome responsibility. Those persons who have committed themselves to become justices of the peace, to support and to provide human service. I think we should commend them. I consider it to be an awesome responsibility, and one that, you know, persons have to extend themselves day and night at odd hours when members of the public or members of communities would require service. Want a JP? You know any JP? I want my passport form to be signed. I want some sort of identification. Also those who have to go to ID parades and feel that they are exposed. President, there's a level of commitment, not only the status of becoming a JP, but the level of commitment that is required. Senator Brown made some, what I consider, some hypothetical situations that, thank God, none of those have presented themselves, because the training, I understand, of JPs require JPs to operate at a particular standard. President, we know that they have an awesome responsibility. And you know, in knowing that about this legislation today, one JP asks whether or not we can reopen the debate about compensation for JPs or extending privileges for JPs. And that discussion would have taken place years ago. It's human service. The value of that should not go unrewarded. The value of that should not go unrewarded. And, President, I am not prescribing for the voluntary service in any way, shape, or form that JPs should charge a fee. Not prescribing that. But one has to examine whether or not we can contemplate to extend privileges to JP in the form of even honorarium. I heard the minister spoke about the question of utilizing JPs for mediatory services. And I think it's a good decision. Excellent decision.
Remember, they are lay magistrates.
And knowing that they are lay magistrates. But, you know, this need for mediation in this country is fundamentally required. The need for mediation and that type of support is a particular skill that don't come easy. The need for mediation can temper some of the violent acts and clashes that take place between individuals and personnels or between organizations, so that nobody can contend the use of any jungle justice. Nobody can tend to utilize jungle justice as any option in treating with conflict. And the hypothetical recommendations that were presented were unwarranted, in my view. And so I believe, and I want to strongly encourage, that justices of the peace should utilize the route of the prescribed training in mediation to support the question of conflict resolution. And maybe, President, if they go that route, given the extensive responsibility of mediation that can call for long, exhaustive hours in arriving at agreements, then maybe there can be the prescription of charging a fee for those mediator services. But I would want to strongly encourage JPs to take on the training as it relates to mediation, so that we can satisfy that resource that is required in the society to lend support to conflict resolution. May it please you, Mr. President.
Thank you, Senator Gale. Senator Scott Motley.
Justices of the peace play a very important role in our society, and an ever-expanding role. The concept of a justice of the peace was first introduced in the UK in 1361, when the justices were to keep the sovereign's peace. And the persons chosen for that function was a very elitist group of persons, really the top of the society. And it is for this reason, actually, why it has evolved that justices of the peace are not compensated for the work they do, because it is seen as a privilege to them and a recognition of the status which they hold in the society. Perhaps, indeed, we will have to reflect on that position, because there's an ever-expanding role for the justices of the peace. In legislation which deals with the protection of human rights, you will find that they feature. And for example, the latest piece of legislation in which I recall that they have to play a really significant and critical role is the ZOZO. Now, Mr. President, a justice of the peace gets 18 hours of training. That's the initial amount, 18 hours of training for doing this task. 1/8. They subsequently get about 3 hours so that it familiarizes themselves with the cell and their obligations in relation to prisoners in the cell. Pardon me? On remand. There are some training programs which are done throughout the year, very wide and very varied topics. I do not think, Mr. President, that training which they experience is deep enough and long enough and consistent enough for the work that they do. And I would like to see that strengthened. I would like them to be made more familiar with the legislation and more familiar with their roles. That will give them the confidence to actually dispatch it. Because when you say to somebody that you actually have to mediate between the security forces and the prisoner in a ZOZO, it's not many people who will have the confidence to step up to say to them, why are you taking this man? And what are you doing with this man? It is not many of them who are going to be confident enough to grant bail in certain circumstances. And because they're working on behalf of the state in a way, but sometimes they're going against the state for the protection of the citizen, I believe that they need extensive training. Mr. President, I am not as enamored as my colleagues are about this, the passing of this bill today, and I'm going to tell you why. In 2018, we debated the Justices of the Peace bill, and we addressed the situation, as has been said, at Clause 8, where it was made pellucid that the parish, as constituted by the Counties and Parishes Act, for which a justice is appointed, shall be the parish in which the justice resides or has his or her principal place of work. And indeed, that if a justice ceases to reside or to have his or her principal place of work in that parish, the justice shall forthwith send a notification of the new parish to the custos, and so on. This act came into being in April 16th of 2018. And now, at this time, we are doing an amendment to it, which in my view, if you make reference to the legislation under which you were actually setting out the position in Clause 8, Minister Sabuda, the thoroughness of that act ought to have indicated then that there was going to be a challenge in how Kingston and St. Andrew was approached. And sometimes I feel as though when I say here that let us slow down with the legislation, let us just spend some time to get it right, I feel that might be I'm being accused of being partisan or political, but I have seen where we rush the legislation like we are ticking a box, when we could really spend some more time on it, just to deliberate. Sometimes we need a little bit more guidance, and then we get it right, so that we don't have to keep on coming back. That is something that I really deeply wish. I can say that there's a particular piece of legislation that I raised my concerns about. And during the sitting, from another jurisdiction, I was sent, actually, the precedent, the crafting of how it was done there. I sent it to Senator Samuda, showed it to Senator Samuda, and when he pondered on it, he agreed that we could do it and made a commitment that at some time we might rethink it. You know, in the what is known as the NITS case, Chief Justice Brian Sykes, and I'm not quoting him, but he indicated that we have many laws on the books which might be unconstitutional but have never been challenged. And clearly it is not the duty of the court to look through laws to see if they satisfy a certain test. But we here sometimes, I think, can just take a little bit more time and go through. I take into account also, listening to the Attorney General in her presentation, how very burdened those attorneys who work with the government are. I know for sure that our technical team is. Sometimes, Senator Longmore, through you, Mr. President, we finish a judge select, a virtual one, we go on to another, and the same persons form the technical team. So I know that they do their best, but I know they do their humanly best. And sometimes the pressures which they have to endure are such that they simply do not get an opportunity to do the kind of research and to dedicate the time to crafting a bill in the way that they would normally do. I want them to be able to have that opportunity. And I implore my colleagues on both sides to consider this sometimes. Mr. President, to be a lay magistrate, you have to be a justice of the peace for 5 years. I cannot say exactly the extent of the training. I gather that there's some training on human rights and so on, but I don't get the impression, because I have been inquiring, that it is, again, the kind of training that we would like. I have heard, because of my inquiries, which had nothing at all to do with this bill which we are discussing today, that they do go to court sometimes. Mr. President, they need to be rostered as part of their training to attend different courts. In other words, if they're going to the parish court to hear a criminal matter, going to the parish court to hear a civil matter, going to the parish court to hear different matters, and not just on one occasion. Pardon me, sir? Coroner. Thank you, sir. Coroners as well. And not just for one sitting or two sittings, but to allow them to absorb some of the training. They need to have clerks there present, not just sometimes, but most times, to assist them in how they conduct the matters. Because with this expanded jurisdiction which they have, constantly expanding jurisdiction which they have, and the kind of penalties which they can impose, they need that level of guidance. Another problem that they experience is that they don't have a home of their own. A home. And I'm going to explain what I mean by home. So there are a number of courtrooms which are assigned to different judges. And sometimes, say the circuit court is in sitting, so one of the senior judge's courtroom is being used by the circuit court. That means that everything shifts. And the lay magistrates sometimes, therefore, are deprived of a space in which to work, and they find a little cubbyhole to put them. This has to change. You see, Mr. President, it's not like they are being compensated. So we have to give them respect. And I said it again, says, we have to give them privileges. And when we give them the respect and the privileges, their authority in the communities grow. Through you, Mr. President, to Senator Gale, they are also trained in the restorative justice process. But again, it needs to be strengthened. And sometimes there's not enough follow-up to see how it's been utilized. Now, I love restorative justice and mediation because I know that if you have an intervention in a domestic matter or intervention among children at an early stage, that is how you reduce the backlog of the cases that have to go to court. If you can prevent a man chopping up a man and stabbing up a man over something as petty as, two brothers were fighting the other day over something that was so insignificant, one is dead. But if you can have an early intervention in family disputes and in conflict at that stage, you actually can help a community to be better. And I think it is a critical role which justices of the peace could play in sorting it out before the tempers get too high, in having that kind of authority and experience that you can actually sit people down and save a life. It might sound simple, but sometimes it's true. When I was growing up in the country, that is a role that teachers played, the pastor play, somebody like a postmistress play, because you had that kind of authority that you could actually intervene in people's personal life. So I want that this would take place and it must be deepened. Mr. President, one more concern. The Lay Magistrates Association has existed for over 35 years. And there's a thrust now. So you have the Justices of the Peace Association, and then you have the Lay Magistrates Association. The Lay Magistrates Association, I think, is a stronger and more vibrant organization, and so people will generally know about them. They have their annual awards, they have their training, and they do participate at a different level. And of course, their training and their responsibilities tends to be different. But there's a thrust now to say that the JPs and the lay magistrates must come under one umbrella. The minister has decided that there should not be two organizations, but one. And that this one body must report to the custodians in each parish. This was decided after a ministerial meeting with the custodians on February 14. It has caused a great deal of concern amongst the lay magistrates who wonder why they are being compelled to have one association after so many years of functioning as they have. And I would just simply say to the minister, if it ain't broken, why fix it? It has been functioning, it functions well. Nobody on the ground is complaining about it. And it's creating upheaval where it need not. So that I would urge a reconsideration as the lay magistrates have expressed their grave concerns about this, this matter. I have brought it to the attention of the minister, the discontent. And I know that the minister, sometimes he's a stubborn man, and sometimes he's very approachable and very amenable. And I hope this is one of the occasions that I find him more amenable, because it doesn't need to be so, especially when people are giving voluntary service. Give them the little privilege. We get more from that than we do from stirring up a conflict and getting them to feel that they are not valued or that they are being discriminated against. So, Mr. President, as I said, we shouldn't be having to do this amendment today, because it should have been contemplated in 2018. But having said so, I indicate my support for the bill, if it pleases you.
Thank you, Senator Scott Motley. Senator Brewer.
During the when you asked if there are any JPs in here, I think that she's a secret JP. But if she, well, I hear you. But, Mr. President, apart from supporting the bill, and I certainly pray that the day will come where more persons will live and work in Kingston and help to solve that problem. Last week's debate on urban planning and so on will no doubt assist that. But I just wondered, I've always wondered, and it is different from when I started life. When I started out and I went to law school, to university, up to when I went to university to study law, I must confess that I'd never met a lawyer. Me personally, isn't that very strange? I had never, well, it is true, I had never in my life spoken to a lawyer. But I ended up going to study law, and the lecturers were the first set of lawyers that I meet. Happily, that has been changing greatly now. Everywhere you go, you meet a family, they have a cousin or a daughter or somebody who is studying law and in the professions and so forth. So that bit of situation would not reoccur. But what I've been wondering, for the regulated professions, say the lawyers and the nurses and the dentists and the doctors and the engineers and the accountants and so on, whether after, say, 5 years in their profession, we could not put in a system where they are automatically entitled to be appointed. And I say that because they are regulated, so therefore, generally speaking, their fit and properness would have been taken care of, and it then provides us a pool. I am not sure whether the teachers can be said to be a regulated profession, but if they are, then it's even better, because for every inner city there's a school, and there are teachers there for 30 years. The community know them very well, and they could go to the school to get their papers signed from the principal. Many principals are JPs. Some senior teachers are JPs. But if it is after 5 years, they were automatically entitled to be JP. I think it would widen the pool. People who generally would be respected, and many of them are accessible people and would make themselves accessible. I don't know whether that will be too open-ended, but it is difficult to get volunteers. Some people would volunteer, but they don't know how. And of course, the process of research on the person is very long. The police has to investigate you, and sometimes, I'm told by one person recently made a GP, took 2 years. Things like that. So I wonder if it is, and I certainly would, because MPs and probably some senators have to deal with the public often and so forth. I too would agree that they should be made automatically JPs too. And they remain JPs after they leave the Senate or their parliament, because they don't stop being accessible to the people after they retire, simply because they are no longer a member of parliament. But I think we should give consideration as to whether we could bring in the regulated profession on an automatic basis, because I think it would extend the availability of personnel to be appointed, Mr. President. And I ask that consideration be given to that as we go further. I support the bill, Mr. President.
Thank you, Senator Brown. Minister? I'm sorry, Senator Brown, thank you.
Mr. President, I wish to thank colleagues on both sides of the aisle for their contribution to the debate. The legislation before us is certainly not controversial, but I think the point around how we do our development of law, how we do our development of policy, and the consultation and the time taken is one worthy of further debate and further examination. I don't think anyone would debate that we have a raft of legislation, raft of regulation, raft of policies that require urgent update. And when you put that desperate need against the capacity of the system to deliver, even from the policy side and the legislation side, it doesn't necessarily match what we desperately need. But your point is taken, and I think it is worth, not related necessarily to this bill, but worth deep consideration on with both sides of the Parliament, looking at how we're going to catch up and modernize our modernize our collective legislative framework and the policy framework that we use to manage our affairs. I think some useful points were made by colleagues, and I think it has certainly put JPs and those who offer to serve in this capacity in a positive light, and a positive light that they deserve to be held in. So I too wish to add my thanks and commendations rather to those who serve in this capacity. It is indeed a noble pursuit. As said, though not a contentious bill, and though I think there were comments, I think constructive comments made on both sides around JPs generally and how we function. I'll make reference to two points. Senator Brown, just for note, Section 12 of the Principal Act, the Justice of the Peace Act, provides for actionable conduct of justices of the peace and holds just JPs accountable by way of the custos rotalorum in each parish, has responsibility to manage and hold the JPs accountable for actionable conduct. The custos ultimately can recommend revocation of a Justice of the Peace commission to the Governor General where Section 12 is breached. So I think in the same spirit that we hold these persons in particularly high regard, if there is breach, there is a mechanism to facilitate action being taken. I think important also to note, on May the 6th, I believe at 7:30, there is a digital town hall which will function as a virtual sensitization session being hosted by Minister Grange and Minister Chuck in collaboration, looking at the issue of domestic violence and the role of justices of the peace. You'd made another point, and though I think it's important to note, you mentioned the impact, and though not directly related to the bill, I thought it important, it having been raised, that it be addressed. The issue of number of rapes and the impact on women in that space and how we create the intervention. I mean, I think important if you're starting to discuss that at all, just to say that, one one is one too much. We are clear that there is some amount. I don't know that there's an exact study of what percentage over the years has not been reported. I know there's cross-referencing with the medical system to determine where persons have gone for treatment versus interacted with the police system. And I know there are a number of other metrics. There's never been a period of total reporting. But I think important to note also, because you have areas in every government where you have, and every period of time where you have some success, and areas where things don't work quite the way you want. When you have, as you do have now, a trend line that shows the incidence of reported rape declining, and you show better results certainly in your courtrooms, I think it's important to acknowledge the process that would have gotten you there. So I'd start by acknowledging the work done by former Minister of National Security, leader of opposition business in the Senate, Peter Bunting's role on the DNA legislation. That was particularly important, and I think would have kick-started some of that process of decline. I think the subsequent investment that we would have made in the last term of government in improving the lab capacity and making sure that we have one of the best labs and highly trained professionals have brought that legislation to life, and we're having success. So you don't have the sorts of chronic reoffending in some cases and serial reoffending that you would have had in some spaces, and that has accounted for, in many cases, a significant decline in the statistics. So that shows, good policy, good law, and investment in the infrastructure to deal with it brings about particular results, and it is, though still, as I said, one incident is one incident too much, we still have to acknowledge that it has declined significantly over the period. But I agree that there is role and greater role for justices of the peace, and the general principle, I think, was made, or what the use of JPs in ZOSOs, I think, specifically is probably the best example of where the capacity can be used much better. But I think just important, and in closing, to note, Mr. President, that these JPs, and certainly the ones that I've met, are of persons of highest integrity. And I want to again thank them for their service. And because the bill is not contentious, Mr. President, and there has been no need for amendment suggested, I ask that the bill be read a second time.
Thank you, Minister Samudi. The question is that the bill be read for a second time. Those in favour? Against? Madam Clerk.
A bill entitled An Act to Amend the Justices of the Peace Act and for Connected Matters read a second time.
Thank you. The Senate will now resolve itself into a committee of the whole Senate to consider the bill clause by clause. I put clause 1. Those in favour? Against? I put clause 2. Those in favour? Against? I put clause 3. Those in favour? Against? I put the title and enacting clause. Those in favour? Against? The question is that I do report the bill as having passed committee stage without amendment. Those in favour? Against? I do report the bill as having passed committee stage without amendment. Minister?
President, I now ask that the bill be read a third time.
A bill entitled An Act to Amend the Justices of the Peace Act and for Connected Matters read a third time and passed.
Minister Samuda.
Mr. President, we have another matter which I also believe to not be contentious, one that, though not contentious, I believe particularly important to our economic fortunes, and certainly as the government has committed to do everything within its power to ensure that we indeed as a country coming off of the COVID pandemic, that we do everything in our power to build back stronger. We believe this is an important step in that reaction, in that direction, sorry. Before us is the Airports Economic Regulation Expansion Fund, Sangster International Airport Amendment Regulations 2021. Jamaica, Mr. President, Jamaica, with the appeal of our natural beauty combined with our unique cultural heritage, continues to welcome record numbers of visitors from around the globe to experience the warmth of our people and our world-class facilities. Though we are clear on the impact of the COVID pandemic, which has certainly had a disastrous impact globally, we are clear on the strength of the industry and its ability to recover. Air transport and airlift capacity are crucial elements which contribute to Jamaica's economic success. The Sir Donald Sangster International Airport in Montego Bay is Jamaica's largest international airport by flights and passenger volume and plays a vital role in tourism, which is Jamaica's largest foreign exchange earner. Indeed, Sangster International is a major driver of tourism in the region, accounting for thousands of jobs at the airport and in connected industries. As Jamaica competes with a growing number of destinations in the Caribbean and the rest of the world, the country's facilities, including our airports, must be operated in strict compliance with international standards and regulations, while offering the best and most efficient experience to airlines and passengers. Members would agree that the cost of such an undertaking would be burdensome on Jamaican taxpayers, but you will also agree that such an undertaking would provide immeasurable benefits to our country's economic vitality. The government is determined to provide the framework that will facilitate the necessary investments in our infrastructure under terms which are favorable to the people of Jamaica. Mr. President, in 2003, the Airports Authority of Jamaica and MBJ Airports Limited entered into a concession agreement for the financing, operation, management, and development of the Sangster International Airport for a period of 30 years. Among the intended outcomes of the agreement was a growth in revenue streams, both aeronautical, passengers, cargo and movements, and non-aeronautical operational goods and services. MBJ has also facilitated infrastructural upgrades, investing some US $287 million to transform the Sangster International Airport into the welcoming, safe, and efficient transport hub it is today. Over the past 18 years of the agreement, the SIA has handled 63.5 million passengers and 763,761 aircraft movements, provided 7,500 jobs, and has contributed US $244 million directly to the Jamaican economy. Of note, the SIA has been awarded the Caribbean's leading airport the past 12 years in a row by the World Travel Awards. Mr. President, I would like to explain the funding mechanism that allows for the significant necessary upgrades that allow for this high level of success. In preparation for the privatization of the Sangster International Airport, the Airports Economic Regulation Act was promulgated in 2002, and the Airports Expansion Fund Sangster International Airport Regulations was passed in 2003 pursuant to Section 21 of the Act. The Act allows for the imposition and collection of the Airport Improvement Fee, AIF, which was to be collected for the first 12 years of the concession. The collection and distribution of the AIF is embodied in a contractual agreement known as the Airport Expansion Fund Agreement, executed by the Airports Authority of Jamaica, MBJ, and the Government of Jamaica. The agreement establishes the AIF expansion account and the distribution mechanism for the funds to be transferred for use by MBJ as the airport operator. Further, the agreement specifically recognizes Phase 1A, Phase 1B, and Phase 2 works as entrenched in the concession agreement. The concession agreement, which requires MBJ to undertake enhancement works and development or expansion works, did not originally contemplate the works comprising Phase 3. Mr. President, in February 2015, the Minister of Transport, pursuant to his authority under the Act, extended the AIF collection period for an additional 15 years. This was intended to allow for the financing of the new works as defined under Phase 3 of the development program. Consequently, in August 2018, Cabinet gave it approval for, inter alia, 1, the implementation of the Phase 3 works at the Sangster International, which concerned the expansion of the runway with the objective of enabling the airport to meet International Civil Aviation Organization runway end safety area standard, and 2, to use the use of the AIF collected at the Sangster International for the purpose of project financing, including debt service obligations and reimbursements of approved project-related expenditure incurred to date. Notwithstanding the foregoing Cabinet approval, MBJ is unable to access the AIF for the funding of the Phase 3 works from the expansion account, as the regulations do not provide for the use of the AIF to fund any other works other than Phase 1 and Phase 2 works. It is important to note that it was intended that the AIF collection period would have terminated at the end of Phase 2. While the Minister of Transport has the authority under the Act to extend the AIF collection period, any amendment to the regulations is subject to affirmative resolution pursuant to Section 21 of the said Act. For this reason, the regulation is being tabled before the Senate for consideration and approval. Mr. President, approval of the amendments will allow Phase 3 works, including the extension of the runway from 2,652 meters to 3,060 meters, installation of runway end safety areas at both ends of the extended runway to comply with ICAO standards, installation of new runway lights, signs, and markings, the relocation of runway 7 approach lights and installation of new approach lights for runway 25 using an omnidirectional approach lighting system, otherwise called ODALS, relocation of the installation of the air navigation equipment, realignment of Kent Avenue to establish adequate distances between the extended runway and the north airside perimeter, subject to the approval of the Jamaica Civil Aviation Authority, acquisition and transfer of lands required for the project, construction of 2 bridges, one across a large north-south drain on the realigned Kent Avenue, and the other from Queens Drive Highway across a large east-west drain to access the Jamaica Defence Force station site and the IAM Jet Center. Acquisition of Sandals Resort International's boatyard, acquisition of the land for road reservation consequent on the design requirements for the realignment of Kent Avenue, security fencing, pavements, and ancillary works to secure and/or define the various installations or property, and pavement overlay of the taxiways and apron. Mr. President, the implementation and management of the project or major components thereof is, unless otherwise determined, the responsibility of MBJ. The AAJ has oversight of the project in its capacity as owner, in the manner contemplated by the concession agreement with respect to the implementation of approved capital development works at Sangster International. The project cost estimate is US $70 million, comprising works cost of $60 million for the runway extension, road alignment, etc., and other costs of $10 million associated with the acquisition of lands, demolition, and clearance to be funded from the AIF subject to these amendments. Mr. President, the Sangster International Airport is the gateway to Jamaica. The financial and infrastructural well-being of the airport benefits airlines, travelers, employees, and indeed the wider community. In order to keep the Sangster International Airport safe and economically viable while providing competitive facilities, I do commend the airport's Economic Regulation Expansion Fund Sangster International Airport Amendment Regulations 2021 for approval from the members in this chamber. Thank you, Mr. President. I invite members to contribute to the debate.
Thank you, Senator Samuel. Senator Morris. Alan.
Thank you, Mr. President.
What I said, but
Thank you, Mr. President. I too rise to support Senator Samuda, the proposed amendments to the regulation which supports the expansion and the works to be undertaken at the airport in Montego Bay. And from what you have presented and from what I also know, what we're discussing here is a process that has spanned 18 years, starting in 2003, but in fact a little bit before. And it's a measure of and an indication of the kind of work and planning required in order to see true development take place. In fact, at the time of the expansion and privatization of the airport and subsequent expansion plans, it's on the heels of what was the beginning of the results of additional rooms to support the expansion of tourism and our tourism product. We speak today of the increased numbers of arrivals, and that is true, but it's not because of it just happened, it's planning. And so this process is a continuation of that, which we fully support. Development and the expansion, it is hoped that once this happens, it goes to the growth and development of the industry, that we do so not in a way that will cause for too many Jamaicans to not benefit. This is a big project which you've outlined the types of works that are to be undertaken and the acquisitions of various lands and the involvement of so many persons. And with an improved airport that leads to greater efficiency in the movement of travel and travelers, we want to make sure that those who are smaller certainly do not get squeezed out of the process. No different, really, than how we see with the development of tourism, the concern of some of the smaller players, whether they be craft traders, independent transport providers. And as I say, independent transport providers, many of them operate from the airport, and with the expansion, we trust that the displacement, if any, will not be too significant to their livelihood. So, my support today is in support of a long-term development planning process that shows that good plans can and must transcend administrations, good plans that when implemented or designed with the overall benefit of the country and its people, can obviously generate consensus and buy-in and support year on year. So where we are today, and the fact that we are looking at a more modernized airport to meet the demand of the more modern traveler, especially coming out of COVID, and how we will continue to support and respond to the needs of travelers. It is, of course, something that we support, I wholeheartedly support, and certainly look forward to seeing it materialize, not only for the benefit of Montegonians, but of course of all Jamaicans as the tourism product continues to expand and develop. Thank you, Mr. President.
Senator Allen, I'm disappointed. I thought you were going to speak about the need to improve White House and the environs.
What could be consent?
But you're not being fair to us. Nothing, Senator Crawford? One minute. Senator Crawford.
Thank you, Mr. President. I see you missed me last week, I understand. Yeah, I was working on it. But, Mr. President, I must applaud Senator
Sorry,
Allen.
Senator Crawford, it's not last week I missed you, it's the week before.
Mr. President, I must applaud Senator Allen on her analysis of the importance of the tourism superstructure being the airport, and by extension, the desire for that superstructure investment to actually be able to touch many, many lives. In fact, Senator Matthew Samuda spoke to the immeasurable benefits of tourism, but also many have also identified in the academia and other areas that the distribution of wealth or earnings from tourism is relatively skewed. Now, as was stated, an airport is very important to Jamaica being an island, and most of our stopover, if not all, come through the airport. We know that we have cruise ships coming in as well, but the majority of our stopover tourists come through the airport. To that extent, we understand that the earnings from tourism must be considered. And I make sure I say earnings because we often reserve this to wages and not profits. And so when we speak to tourism, we often speak to the number of jobs that it creates. However, there is also another person about the number of entrepreneurs it can facilitate. And one of the areas of entrepreneurship with the lowest barriers of entry is the craft. And by extension, this is the area of tourism ownership that the poorest within our society, or the least financially blessed, especially historically, can participate in. Another area of this participation in entrepreneurship is, of course, the transport. And to this point, Mr. President, Juta is in dire straits. And one of the reasons Juta is in dire straits is because many of our hotel investors have started to become vertically integrated, and by extension reducing the demand, especially from airport to hotel travel, that Juta used to actually embrace. Within this period of slowdown, and slowdown is a term used maybe for the buses, but for the craft it will be a stop. I am disappointed that the government has not embarked upon a preparation period so that there can be a better circumstance for these individuals when the industry recovers. And clearly, an investment in the airport suggests an assumption that the industry will recover. Now, Mr. President, one of these things I am disappointed that has not been implemented is the Authentic Jamaica brand that was actually copywritten by the government in 2014 for the protection of craft in Jamaica. You see, Senator Samuda, there are some countries like the Seychelles that make over $100 per person on average on craft. In Ethiopia, they make about $50 on craft. There's some research in Jamaica that suggests we are at about $13 coming from craft. And one of the realities of that is because we have not protected the vendor sufficiently, but we definitely have not protected the craft makers, the designers of craft. And there's a misunderstanding within the Jamaican circumstance that we often train the vendor to make the craft, when the vendor is a seldom the person who is the craft maker. A lot of our investment in craft development has been to the actual vendor of craft, when the people who went to Edna Manley, etc., because of the lack of protection, they don't come to develop adequate craft. And so when you go to the craft market, Senator Bunting, you know what you see? You see an elephant there. When you go to the craft market, you know what you see? You see a giraffe there. You see a fish that don't have no specific representation of the Jamaican culture, but you see that fish. And to that extent, the types... Yeah. You see a well-blessed Rastaman who might not be able to be shipped overseas based on the inability of the blessings to fit. So now when you check this out, Mr. President, you get to recognize that the craft in the Jamaican circumstance does not reflect the Jamaican culture, does not reflect the Jamaican heritage, and by extension does not serve the reasons for craft consumption. And that is one of the reasons why we are selling so few craft. When you check it out, a person who travels to Jamaica and he wants to buy a piece of craft for self-actualization, to remind himself that he achieved a goal, the elephant don't remind him of Jamaica. The giraffe don't remind him of Jamaica. Unlike when I went to Africa and I get a spear, or when I went to Mexico and I get a Mayan plate, or those different things. And when I shell down London, which the JLP continued to lie that I spend government money, but I won't speak to that today. I was invited for my academic prowess. Many would not understand that. But The reality of the situation is that I thought we could have taken this slow period of almost 12 months to have now focus on the development of appropriate craft. So when we get back into place, that we would have craft reflecting our athletic prowess, craft reflecting our natural blessings, craft reflecting our history, which we don't necessarily have at this time. Equally, local production of craft has almost died. The importation of craft is the #1 basis upon which we actually have craft distribution. And so while we're investing in fixing the airport, and it is welcome, we have not similarly invested in the development and production of craft within Jamaica. Now, when we were in government, we actually sought to implement what we call one craft per community. And based on the community's natural blessing, we would train that community to develop craft coming out of what is acceptable, be it bamboo or even the thing in East Rural where the cement come from, the gypsum. There is actually methods of carving and shaping those things, straw in some areas, that we will have a community craft effort. So that when you say tourism, it isn't reserved for where the tourist is, but there could be development in Manchester of craft, Senator Bunting, or in Portland, or in Clarendon, where the vendors could know that I can get this base product from craft in this particular area. I'm disappointed that within this year of slowdown, we have not seen that development. We also is disappointed that, as I said, the Authentic Jamaica brand, which was reserved for Jamaicans only, and the proposal within the tourism policy that imported craft should have permanently stapled the name of the origin of the craft. I think that was one of the methods we thought could reduce the consumption of imported craft, because why would you come to Jamaica and buy something branded permanently China? Or why would you come to Jamaica and buy something permanently branded Indonesia? And so we proposed at that time. And you see, one of the good things about a slowdown is that when it slows down, it is easier for those who are intent on catching up to catch up. And unfortunately, we have not seen similar proposals. There's a saying, Senator Samuda, that says, water in and of itself does not a tea make. And so the tourism effort cannot end with just an investment within the airports, and an investment within the hotel infrastructure, and an investment within the road network, and not similar investment in the people's ability to become entrepreneurs within the craft market. The final thing, sir, is the registration of craft vendors. This has been an ill point for a very, very long time. And to this point, even a year after it has been closed, we have not taken the opportunity to properly register persons in Swansea, and to properly, Swansea Craft Market, and to properly register persons in, what that one name again? I want to say Duns River, but it's not Duns River, it is Ferngully. And so, if we don't properly register Swansea and Ferngully, then we cannot implement schemes that are going to be very necessary moving forward. Schemes such as, for example, the rotation of visitors, of craft vendors on the pier. That was one of the things used to ban some of the persons who wanted to be on the pier in a rotation, because we don't know if the cruise ship is going to want their people to go to the craft market. We don't know if the cruise ship is not going to want to have a bubble created on the pier to make sure that vaccinated persons are the ones who are selling, or to ensure that tested people are the ones. And so when we look at a pier rotation system, if you don't register these craft vendors, it is still going to be a basis upon which they will be subtracted and exempted from benefit. I think the government should also have encouraged the hotels to have rotation. Craft vendors rotation. So yes, the craft market has been closed, but with a little 30% and a little 40%, with effort that we see put into making the airports great, and we celebrate that effort. Similar effort has not been put into place to have a rotation system, so craft vendors could actually go and stand to a government-centered rotation system. We have not seen that effort. We have also, unfortunately, not seen sufficient preparation of of our buses so that they can now acquiesce to what will be the demands of the cruise ship. I was reading just this morning, Senator Morris, that the cruise ship might be coming back in June. Just this morning they said that the CDC was likely to allow for cruise to take back place in June. And we'll be running and scampering and trying to fix everything that we had over a year to fix when the cruise ship reach. When the cruise ship reach and say the bus have to prove that it has been properly fumigated and this and that, the bus man now have no fumigator. We are run up and down at that time to say, okay, let's do it. When the cruise ship reach and say that him have to have proof of vaccination, we'll be running at that time. When the airplane reach to this new pretty airport, that is when we're going to say, oh, them can't go into this bus because him don't have proper social distancing, whether by removing a particular seat or something like that. So what we're saying in essence, sir, is that we understand the importance of the superstructure. We understand the importance of the infrastructure. But we also understand that we will continue to have high leakage from the tourism earnings if we don't improve the people's ability to take advantage not only of low wages, but of high profits through entrepreneurship. And so I hope that this is only the start of the government's effort to create a better tourism product, to include the communities, the craft vendors, and the buses, and to ensure that when the time comes, our craft vendors are registered, that their rotation is properly organized, and that our bus owners are prepared and are not stifled by vertical integration. With that, I thank you, Mr. President.
Thank you very much for a comprehensive, wide-ranging discourse on the tourist industry. I just can't figure out why you said, and I can't figure out why you said, and Manchester, Senator Bunting. I'm not sure of the link. Minister.
Mr. President, I suppose what would be appropriate. I'm not quite sure that the airport expansion took into consideration the road all the way to Fern Gully, but I notice your the latitude you have provided has certainly increased since my entry into the Senate in 2016. But it is always a pleasure to hear the contributions of colleagues. I know the tourism space is one near and dear to the hearts of many members, certainly on this side and certainly on that side. And I've always appreciated the interventions of Senator Crawford and in recent times Senator Allen on the matter. I know the passion is there. We too are passionate about the workers in the tourism industry, local, the local entrepreneurs that benefit, and certainly not least of all the craftsmen. We, however, understand, or rather, I won't be exercising the same or requesting the same latitude in my closing to address, as far as Fern Gully. What I will say, Mr. President, there's one point of divergence that I think has to be made abundantly clear for those watching both live and those who could be watching at home. Any suggestion that over the last year, while the significant fallout because of within the tourist industry, because of the COVID pandemic, and the downtime, as it was phrased, has not been used for a lot of work to be done on the policy framework, on the legislative agenda, on training for our workers who would have benefited from the digital training platforms, I think would really be unfortunate. Because whereas I applaud and acknowledge your love and commitment to the industry, Senator Crawford and Senator Allen, I think any any well-thinking Jamaican would also acknowledge the deep love and commitment for this industry and the workers and players in that industry exhibited daily by Minister Edmund Bartlett and his team. So, as we often say, we don't want to diminish the efforts of those who invest their time and life into the development of an industry that benefits so many of us in Jamaica. The other point I think that needs to be made as we look at the benefit of this investment and the benefit of this industry to Jamaicans, and a point that I think needs to be made, is that as advanced as airports and air travel is becoming, it is on the back of the hard-working Jamaicans that SIA has developed to the reputation that it has. And I wish to pause here also to acknowledge all the men and women who work at SIA in the varying components of the airport. I speak specifically of the air crews and the varying professionals that manage the flights coming in. I speak specifically of the customs officers, the PICA officers, of those who work in the hospitality components of the airport, of those who work from the parking lots all the way in, and the thousands of professionals that ensure that Jamaica is open for visitors and for business, both at SIA and MBJ. I have come to know many of them during the course of the last year, because we certainly weren't twiddling our thumbs as we had to manage the controlled re-entry process for Jamaicans coming back in after we gradually reopened our borders to manage the spread and potential impact of COVID. And I can tell you that these Jamaicans are patriotic. They work around the clock. And with them at the helm, I have no doubt that this airport will continue to grow and its development will see significant benefit for the country. Mr. President, it is not a... You know, Mr. President.
Senator Samuda, make sure you turn off your mic before you make any comment.
I shall, Mr. President. Following the same line of reasoning from colleague Senator Motley earlier, if the process was applied to the law, then we'd have contemplated a phase 3 and phase 4 in the expansion in the same way, and we wouldn't have to be amending here. So even wisdom of the past has its limits. And we just have to acknowledge that when there needs to be legislative amendment to facilitate the continued growth and development of the country, we will bring those amendments to the Parliament for approval so that we can ensure that all Jamaicans enjoy the benefits. We are at a critical nature. I didn't interrupt you, Senator Crawford. President, there's a lot of work being done on the craft industry. And to be frank, having served at the Bureau of Standards and seen the interaction between the Ministry of Industry, Investment and Commerce, and indeed the plans that are afoot with the Ministry of Tourism, with the Artisan Village, and many other things that Minister Bartlett has time and time again spoken to, and that we expect to see come on stream within the shortest period of time. I am confident that this development, and indeed all of the investment and time being put into the growth of the tourism industry, will see a people-centered recovery, and we will indeed build back stronger. And it is with that, Mr. President, that I conclude the debate on the resolution and ask that it be approved, Mr. President. Thank you.
Thank you, members. The Minister is asking for the approval of the Airport's Economic Regulation Expansion Fund Sangster International Airport Amendment Regulation 2021 resolution. Those in favor? Against? Minister Hill.
Mr. President, it is now 3 minutes past 1. I make that note, Mr. President, because it's so unusual that the leader of government business would be making their request that, having passed through Fern Gully and traveled to places that we wouldn't want to go, I won't even mention Manchester, nor the places that Senator Brown would like us to travel. Mr. President, we have no further business to be conducted today. And with that, I ask that the Senate be adjourned for a date to be announced.
Thank you very much, Minister Hill. And thank you very much, both Senators Samuda and Campbell. The question is the Senate be adjourned for a date to be fixed. Those in favour? Against? This Honourable Senate now stands adjourned for a date to be fixed.
Where that now? Fern Gully. No, but that's not clean.